My name is Jessica Saxon. I'm a civil rights advocate and litigator from Washington, D.C. I'm here to provide a public notice in accordance with USCS Rules of Civil Procedure, as well as the Rule 17 and 20 of the United States Supreme Court. The Constitution for the United States of America is the overarching requirement that every state must follow. I don't think anyone here would disagree with that. States cannot enact their own alternative legislation in substitution for the guarantees of the Constitution. That would mean that the Constitution is not as powerful as state laws. Clause 1 of the Fifth Amendment states that no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. The state of Iowa has enacted its own alternative legislation that makes prosecuting attorneys, police officers, or sheriff departments charged by way of information as opposed to indictment. That is unconstitutional and it is illegal. An emolument violation is when you pay a public official to break the law. The Constitution actually has two areas that refers to this. The first is Article 1, Section 10, where it says that no state shall create any law that shall impair the obligations of contracts. So that means that police officers, your prosecutors, your judges are all under contract. It was a contract to perform based on their oath or affirmation that they took to uphold and defend the Constitution. So those contract perimeters that are defined within the Constitution of the United States would be a violation of that Article 1, Section 10 that I mentioned previously. The next one is the 14th Amendment that states, no state shall create or enforce any law that shall abridge the privileges or immunities of the United States citizens. Privileges and immunities of the United States citizens are at a very minimum those that are enumerated in the Bill of Rights and the first 10 amendments. So the state of Iowa, unfortunately, has an inferior constitution that is permitting public officials, such as your sheriff's department, to go out and charge by way of information as opposed to indictment. Because of this, we have an unusual, unreasonable amount of people that are currently incarcerated in prison currently right now. So in the United States, we have over 700 currently in prison. That includes people that you guys have arrested here. I am here to provide notice to you publicly that if you continue to pay public officials to break the law, that there can be criminal sanctions that can be brought. We do not want that, but I must make people aware that you cannot pay people to disobey the law and commit a crime. So I'm asking you honorable individuals, if you would please look at Clause 1, Amendment 5, confirm that what I'm saying is true, and then direct the public officials that you are paid to act accordingly to the law and consistent with the Constitution and the rights that are secured there. I have a notice that I'd like to put on the record, if I could.
Yeah.
Thank you.
My name's Stanley Downing, and I'm the National Civil Rights Advocate and Litigator that Ms. Saxon was just talking about. The reason why I'm up here is I want to just provide a little bit of clarification for you guys, right? So the reason why I'm here today is because, again, you guys pay the Sheriff's Department. You guys formulate the budget for the jail. You guys formulate the budget for the Sheriff's Department. If the sheriff is relying upon a judge providing an order because the judge relied upon a prosecutor who relied upon an inferior state statute to deprive a person of rights that are guaranteed by the Constitution of the United States, that means that that sheriff is now implicated within the criminal act of deprivation of rights under color of law. It is a crime. Anytime that you rely upon an inferior state statute to deprive a person of rights that they're guaranteed by the Constitution of the United States, that is a violation of Title 18, subsection 242, deprivation of rights under color of law. What that says, it says that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits that crime. Now, this is a per se crime, and I want you guys to understand that I have roughly 34,000 affidavits from actual victims here in the state of Iowa. And these are what's called prima facie evidence for a per se crime. It's a per se crime because we don't have to show that these public officials intended to breach their obligation. Simply by virtue of the breach of the Constitution, all elements of crime have been met because their willfulness and their knowledge derives from promise they make. Now, we don't want anybody to get into trouble. We're here because we want to inform you guys and let you guys know that there is an unconstitutional situation that is affecting a lot of states. Right now today, there's 13 states that do not conduct a grand jury. There's another 32 states that permit their prosecuting attorney to charge by information or indictments, such as the state of Iowa here. Prosecutors may not disregard the obligations that they have codified in the Constitution of the United States. And so, This is going to the United States Supreme Court. We're preparing to argue it. This is I believe, stop number 9 of 55 that we're doing over the next 30 days, because we want to make sure that we bring it to you guys' attention, because you guys, as of this moment, whether you realize it or not, you are paying for crimes to be committed. You are paying for a deprivation of a constitutional right amongst your own constituents. And this is a very, very big deal, because today, as Ms. Saxon just said, there's more than 700,000 people currently in prison here in America on direct facial constitutional violations, because these states haven't followed the very, very basic procedures and processes codified and written for all to see in the Constitution of the United States for the adjudication of a crime. That's a big deal. So, I would welcome you guys to please take a look at Clause 1 of Amendment 5. Confirm the things that we're saying, and then let's direct the agents to act in lawful constitutional manner. The reason why is because once made aware, once notified of this condition, if you pay a public official one more time to commit that crime, then that goes from negligence into willful illegal acts. And there's a big change there. So we want to make sure that you guys understand that upon having been provided this notice, that you guys can go out, you can confirm the things we're saying, and then we can direct those agents to act in lawful constitutional manner. And again, there's 2 ways to mitigate your culpability once being notified under the laws of criminal conspiracy, right? Number 1 is you must notify the authorities of crimes. The proper authorities for the crime of deprivation of rights under color of law is the FBI. So I would welcome you guys to contact the FBI, let them know that this is happening, and let them initiate the investigation. Number 2 is that you notify your co-conspirators of your intent to no longer participate. Whether you're willful or negligent doesn't matter. You need to notify the co-conspirators that you're no longer going to participate in it, and that you're going to direct them to act in lawful manner, or else they're not going to get paid to do the work, because that's the role that you guys play within the system of government that we have here. So the specific law with regard to conspiracy for public officials, what it says that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in prevention of the commission of same, neglects or refuses to do so, may be joined to dispense the action. So I want to finish this right here. We have been received notification from Kash Patel, as well as also Senator Kennedy, who is a member of the Senate Judicial Oversight Committee, obviously. And they have let us know that any time that a state judge or a state prosecutor violates federal law, they are subject to arrest, right? This constitutional provision is absolutely federal law. There is no higher federal law than the Constitution. So we have an opportunity here to correct some actions and mitigate some unlawfulness, but it's going to require you guys to take action. So I would welcome you to do that. Thank you guys so much. God bless, and have a great rest of your day.
Okay, thank you.
We shall be free, fists raised high, under the burning justice sky. Truth will